Good evening, everybody, and welcome to our webinar this evening. My name is Ben Frederick, President and Chief Broker of Ben Frederick Realty Incorporated. We have on the screen with me some of my associates. We have Cheryl Sedera. Wave, Cheryl. And Cheryl's been really an integral part of our team. She's worked with many of our clients to help them get transactions done, and just really a super gal, really excellent at learning the business and learning the ins and outs and nuances of the business. And she's really has a lot of experience running the property management side of the business. And she's also getting involved in transaction management and getting involved in helping people buy and sell investment properties. So it's a great thing there. And Will Cannon is also with us this evening. Will and I started working together probably 10 years ago. And Will is one of the brokers here at Ben Frederick Realty, and he's working with buyers and sellers, helping them acquire apartment properties and investment properties. And then our young whippersnapper is Tom Fair. And Tom has been with us for a couple of years and really helping people, focusing really on like Charles Village and Old Goucher neighborhoods. Again, helping a lot of people meet their goals and objectives with their rental properties and investment properties. And this evening, we're really excited to have Jason Fratto as our special guest. Jason is an attorney with Tapper and Fratto, and Jeff Tapper, his boss, his mentor, has been in the business a long time. Jeff is quite old, you see. And Jeff is really a terrific guy. We've recommended and referred many of our clients to Jeff Tapper's office to handle collection matters, collecting past due rents or from tenants, pursuing tenant collections from tenants that have left our units owing money, as well as Jeff and Jason have also helped us when we've had issues with tenants where we've had to go to court, either to sue the tenants or the tenants are suing us to work out claims. And so they're really specializing in litigation, particularly with landlord-tenant matters. So Jason, welcome. We're excited to have you here.
Excited to be here for everyone. Can you all hear me fine? All right, yeah, had to switch the audio because I was still having problems and I didn't want to have any issues while we were having this discussion. So I'm more than happy to be here. I appreciate you having me come along and come on and hopefully able to answer some questions for people.
Yes. Yeah. So, Jason, you're mentioning that you went to college here in Maryland, but you did not grow up in Maryland. Where did you grow up?
Yeah, I actually grew up in Salt Lake City, Utah. And just by happenstance, went to a college fair and met the Dean of Admissions for McDaniel College, formerly Western Maryland, at the college fair that she just happened to be passing through. She didn't even expect to be sitting at it, and both of us talked about it. It was kind of by fate that we met each other. So as soon as I met her, my parents and I both felt that there was something different with what she was saying, and so we came out and checked out the school, fell absolutely in love, and have been here ever since. So now I feel that's in the past. I'm now a Marylander. This is home. So
Great. And how did you get interested in law?
So I actually, that's a good question because I don't actually know the answer. I can tell you that even back in 1997, I think, or 98, when Liar Liar came out, I even then knew when that came out that I wanted to be an attorney because I watched that movie as a 12, 13-year-old thinking, is that really what I want to do? And apparently it never actually changed. But I, always loved the idea of debate, the idea of forming your opinions, not just arguing for the sake of arguing, having to find the reason for something. And I think that's where it came from ultimately. And similarly to me falling into McDaniel by happenstance, I just happened to meet Jeff Tapper, my former boss, now partner, by happenstance. My summer or spring break of my first year of law school, lived in Owings Mills and just happened to be looking around and ended up seeing the name of a different attorney in the same building. And I walked in and I said, does anybody happen to take applications? And he said, how about you come in and talk to me? And we sat down for 45 minutes and had a conversation. And 12 years later, we're partners and he still plugging along 5 days a week rather than 7, but we're plugging along together like an old married couple.
That's great. Good. Excellent. So, with respect particularly to landlord-tenant law and landlord-tenant matters, do you file rent cases yourself, or do you recommend using a service, a third-party rent court agent service to do that?
I will tell you that 99.9% of the time, I would tell clients to use a rent court agent. The reason being is unless you have a law firm, which there are a couple that have a rent court agency side to their business, it's going to be exorbitantly expensive for you to have an attorney do so rather than necessarily a rent court agent. I've seen people use click notices, which I think we were talking about earlier. I don't know. Amernick was one that we had in the past that people would tell them to do. I would also tell them to talk to. It used to be called Bristol House. I think it's still called Bristol House. With Blybaum's office, Gary and Sam Blybaum, Blibaum. They also have a rent court agency that they do. So if you're looking for someone, if you are looking for, and I would tell you if you're not doing it by yourself, if you're gotten to the point where you're about 5 or 10, I would contact one of those rent court agencies. That being said, we have represented clients, and the times that I would say obviously you want to have an attorney represent you is if your tenant has an attorney on their side, or if it's something that you think may lead to further issues. A lot of times we've had clients say, hey, we filed this failure to pay rent. We are anticipating our client is Bristol, I'm sorry, Brist as in Tom, OL. But you make sure to look up Gary Blybaum, Blibaum, and that'll be the one that you can contact them. But I've had clients say, Mr. Frederick, you'll contact me and say, hey, I'm filed a failure to pay rent. I have an anticipation that this client's going to be filing a rent escrow in response, or that they're going to say this is retaliatory because they did X, Y, and Z. And I think that's what's going to happen. So, I understand that I'm going to have to pay you, which is, again, going to be much more expensive than using a rent court agent. But I want to get you involved because I think this is going to be something down the pike. There's going to be more things going on. And in that instance, we will represent clients. But it is much more on a case-by-case rather than a blanket rent court filing.
Got it. So for routine matters where it's just the tenant hasn't paid and there aren't really any underlying issues, using the rent court services is the best way to go. But if there's something unusual or if there's something out of the ordinary, because the rent court agents, they're not lawyers and not really there to advocate for you. It's just if the tenant hasn't paid the rent and there are no really serious underlying issues or issues, then it's easier to use them. Got it. Okay.
Yeah, and by and large, you're going to see, and for those of you, I'm sure most of you have used rent court agents, but if you haven't, if there's any issue that the tenant's going to bring up, all the rent court agent is going to do is say, I'm going to have to postpone this and bring in the landlord, or they're going to have to come themselves. So, and it then just comes down to an issue at that point. If you wanted to contact an attorney, again, it's a cost benefit analysis. Am I willing to pay the money, try and fight this? Is it going to be that contentious? Is it going to be that convoluted, or is it something I'm going to be able to show the judge? Here's my ledger. This is what's owed. Here's the lease. This is why it's owed. They haven't paid, and the tenant can't show it. By and large, you can represent yourself in those. But if it's something where they're, again, arguing that they're going to file an escrow, there's retaliatory eviction's a big one that comes up, things like that, then I would say, at that point, you would potentially want to discuss getting an attorney.
Okay. Can you explain retaliatory eviction and, what it is and what it isn't?
Sure. So retaliatory eviction, there's not a specific definition to say this is retaliatory eviction. Well, what it can spring from is if a tenant takes an action and then you give a failure to pay rent, or the more common mechanism that comes about is you either giving them a breach of lease or a non-renewal. You have to be wary of when you give those. And the reason is a big case that came about, which our office was actually involved in, was Felicia Lockett versus Blue Ocean, which is the one that then actually set the standard for the fact that you can't charge water for failures to pay rent. What came about from this case. What was involved in that case was the woman had started a tenant association. And I don't know if, for those people who have multiple units, if you've ever had tenants try and do so, that is actually something is specifically stated. If a tenant starts a tenant association and you come back and give them a non-renewal, you have to have a reason for doing so. Otherwise, it's going to look retaliatory. Similarly, if they file a rent escrow action against you, and this actually is codified. So this is where you have to make sure when you're giving your non-renewals to pay attention. If they file a rent escrow action against you and they are successful, it will be presumed that you are being retaliatory if you give them a non-renewal within 6 months of that rent escrow. So unless you have a reason that you can show a judge, you've actually flipped your burden to say that you have to prove that you're not being retaliatory. Otherwise, you can be sued for up to, I believe it's 3 times the security deposit, or 3 times, the security deposit. I think it's similar to the wrongful withholding, if I remember correctly from the Lockett case. And so retaliatory actions are ones that you are taking action to try and get the tenant out for something that is perceived as a result of them doing something, whether it's, again, them filing the rent escrow, tenant association, even something as simple as calling the cops on you for if they're saying you trespassed, even though it's your property, you gave them notice, you come in to do an inspection, they call the cops, you then give them a non-renewal. That looks retaliatory. So when you're doing so, if you're giving non-renewals, make sure that there is a reason that you have it, even if it's just a business decision. This is a fair market value of a place of what I believe I could get for $1,500. This tenant's only been paying $1,000. We've had multiple issues with them not paying on time. It's been a business decision. But if you're just doing it because you say, I don't like that tenant, that's where you can get yourself in trouble and get sued for treble damages.
Okay, good. So the idea is that if there's an issue with a tenant or dispute with a tenant, either a rent escrow case, you wait till the rent escrow case is over and complete, and then wait at least 6 months before you raise the tenant's rent or give them notice to terminate the lease, unless there's a good, valid reason that
Correct.
they have animals in the property or there's drug dealing or something, that is really a firm, definite reason to evict them or to cancel the lease or terminate the lease. Make sure you have that documented.
And that actually leads to where you said if they have pets or drugs or etc. There is a wording that you want to be wary of when you're giving either a non-renewal or a breach of lease. You have to be wary of what you are giving. So for example, breaches of lease have 2 sets. You can either give a 14-day or a 30-day notice. 30-day notice is actually 30 days. So if you gave a letter today to your tenant for something, let's say, Cheryl, you're my tenant and you started a fire in my place. If I was giving you a letter today, I could say you have to be out on or before November 26th because the 31 days in October. So we have 4 days here plus 26 days in November. But the actual statute in Maryland for non-renewals for tenants holding over say months notice. So if I was giving Cheryl that non-renewal today, that was for the 60-day notice that you have to give, I couldn't tell her she had to be out by December 26th. It would have to be December 31st. You have to go pay period or rental period to rental period. And so, but on those breaches of lease, you can give actual 30 days. Just make sure you're counting those 30 days correctly. I've seen clients lose cases because they gave a letter which told the tenant that they had to leave 29 days, not 30. And you have to be very wary. So if you're ever worried about it, if it's towards the end of the month, like today, if you had today, just give until November 30th, give them the 34 days and you've covered yourself.
Mm-hmm. Okay, good. Excellent. So in Baltimore City, you have to give 2 months notice to terminate a month-to-month lease under normal conditions. If there's a lease violation, do you have to give 2 months or 60 days notice, or is it 30 days notice for lease violations in Baltimore City?
That's a great question. That's a question we get all the time. It's separate and apart, because the 60-day notice that you're giving on a month-to-month tenancy is that non-renewal. You were telling them, I'm ending this lease. I'm not renewing it when this comes up. So you have to be out on or before December 31st, 2020. The breach of lease statute is a separate statute. If they have a violation of that statute, the 30 days is still fine. So the 30 days or the 14 would apply. So even if you're in Baltimore City, you can give them that 30-day notice. The 14-day notice, the difference between those two is for what's called clear and imminent danger. I will tell any of you listening, I would use it very, very sparingly. Guns, fire, and police involvement with drugs would be about the biggest ones. And even then, I can tell you, I had a 14-day one where a tenant started a fire in her apartment. Well, not a fire, it was smoke, because she left something burning so badly that she sent herself and a neighbor to the hospital due to smoke inhalation. And a judge still said that was not clear and imminent danger, because it was a one-time accident rather than necessarily clear and imminent danger. So it's a very high standard if you're using that 14-day. And I always tell clients, if you're asking whether or not you should do the 14 or the 30, do the 30. Give yourself that extra 16 days of the tenant being there, but don't give a judge the reason to make that determination if it's clear and imminent or not. Just give them the 30-day notice, because so long as you can prove that there's a breach, you're fine. You don't have to prove that extra step for that 14-day.
Good. Okay. So we're all, we've all been struggling and suffering and dealing with the pandemic and all of the issues related to that. The governor signed an order prohibiting evictions. The courts closed for a number of months in March, April, and May, June. The courts only opened in August. Is that right? They started reopening in August?
In terms of failures to pay rent and even filing them, yes. And for tenant holding overs that started back in July and breaches of lease were August, or vice versa. But yeah, they did a tiered system where things didn't get truly back to normal until August 31st.
What are you seeing in the way of a backlog? So if a tenant, doesn't pay their rent October 1st and you file the notice October the 5th, what kind of dates are we looking at for court cases to be heard?
As I said earlier, we don't file them personally, but just in speaking with clients, I'm hearing January and February, and this is for cases that were filed even prior to. You're probably not seeing these cases coming up until at least March, just because the case or the courts are setting these cases on different hours rather than the normal two dockets, the morning and the afternoon docket. They're doing tiered dockets for every hour and a half, because they have to obviously limit the number of people who are coming in. So unfortunately, because I don't file them for failures to pay rent, I can tell you I wouldn't know as much necessarily as you would, Mr. Frederick, or anyone on the call, but just secondhand, it's still months down the road that you're seeing these cases being set in.
Right. Yep.
That being said, we have filed for our clients both in Baltimore City as well as other jurisdictions. We have filed for breaches of lease, tenants holding over, and wrongful detainers, which have been set in. We have a couple that are set in for Howard County that are set in for December. We've had some tenants holding over that were filed specifically in Baltimore City that are set next month. But we've then had some in other counties. I think it was Anne Arundel that aren't set until January. So that's become jurisdiction specific and jurisdiction dependent, but they are going forward with those cases as well, and have been, whereas the governor's moratorium on eviction specifically covered failures to pay rent. These other three actions were exempt from that. So they are still able to, property managers and owners are still able to move forward if you have that situation.
So eviction for non-payment of rent, has been banned by the governor and also now by the CDC. Is that correct?
That is correct.
But you can still file for evictions for breach of lease and what else?
Tenant holding over
Mhm.
and wrongful detainer. So if you have somebody, and not everybody may know what that term means in the legal term for a squatter. You have a squatter on your property. That's what the legal term is, a wrongful detainer. And so those actions are still moving forward. The courts are still processing them. They are still having the hearings for them. And so those, albeit a little bit later than they normally would be, just because of the limited amount of cases that they're actually hearing, are being set in virtually in the normal course that they would have been normally. And so, in fact, we had one that was just set, I think it was 2 weeks ago in Baltimore City, that my associate took. So they are hearing them.
And they're hearing those virtually?
They can be.
Okay.
In fact, the majority, and aside from when a tenant is current, and Mr. Frederick knows this because we represented him on myriad ones, we also do collections. And so we have seen both on both ends, both while the tenant's still there, as well as for our collections cases, that you can ask for virtual hearings. And I will tell you truthfully, I come from a family with some medical pasts and medical issues. I don't feel comfortable going to court. And my partner had some medical issues in the past, so he feels the same way. And our associate, his family has medical history. So even though he's a healthy 36, 37-year-old man, he doesn't want to risk himself for his family. So as a result, we've been asking the courts for these motions for remote hearings, and they have been granting them all, but I can tell you one or two examples of where a judge has denied it. Other than that, judges have been granting them almost by rote. In fact, it's become so ingrained now in the legal system that they've actually created a court form for it specifically to ask for a motion for a hearing remotely, whether it's via telephone or if you have the capability. They've been doing Zoom hearings. I had 3 cases 2 weeks ago via Zoom with Baltimore County District Court.
Wow, interesting.
Jason, are the court cases for wrongful detainer, breach of lease, and tenant holding over still backlogged as far as the failure to pay rent cases?
Not that I'm aware of, just based off the fact that when we file these cases for our clients, the wrongful detainer, breach of lease, and tenant holding over, all 3 of them, none of them were filed prior to the pandemic. They were all filed post-pandemic. Clients gave the notices, whether the notices themselves may have been prior to the pandemic, but they came to us. I had one that came to us in August. We filed it in August. They filed, and the hearing was held in September, and we already had the eviction.
Yeah.
We had one where a client came to me with 2 cases. I want to say 3 weeks ago, I guess close to 4 weeks ago. It was the starting of the month. We filed those. They've already been set. I've already settled one with an attorney that got involved in the case. So they seem to be being set in because they've always been separate and apart in terms of the way the court looks at them. They have their failure to pay rent docket, and then the tenant holding over, breach of lease, wrongful detainer sit not in the civil docket, but they sit necessarily in the same courtrooms as a civil docket. So because they are on a different track, they don't seem to be backlogged with those failures to pay rent.
Mm-hmm. Interesting. Okay, good.
I will tell you, in terms of your question about the can the tenant be evicted? Isn't that against the CDC recommendation? I will tell you that the CDC recommendation is just that. It's a recommendation. The only thing that the court, the state has actually accepted was the governor's mandate for failures to pay rent. And that's the reason that we are still able to file the evictions, file the warrants of restitution, and actually have the evictions. As I said, we've had, I want to say 2 or 3. I can't tell you the exact number just because we turn the actual evictions over to the client, but we've filed 3 or 4 warrants just on the behalf of the clients that have been gone through. So there's no necessarily any issue on those breach of lease, tenant holding over, or wrongful detainers.
Okay. Um, let's see. And how is it going with filing with the sheriffs? Are you hearing anything about how the sheriffs are processing paperwork and how quickly that's going, or how slowly that is going?
Again, only turning to the breaches of lease, tenant holding over, wrongful detainers that I can speak to, just because we don't. I haven't heard clients say it about the failures to pay rent, just because they're obviously set out anyway, back into 2021. But we haven't had any issues. The courts have processed the warrants of restitution in those cases, and as a result, they have then we've turned it over, because we don't actually do the evictions on behalf of our clients. We do all the, we'll do the case, we'll file the petition of warrant of restitution on client's behalf. The court then turns it over to us, and we have the client set up the eviction, just because that way they can he or she can be there with the locksmith. They know when they're available to do so. I don't want to be setting an eviction for you, Tom, and then you not be available that day, or you can't find anybody to do the changing the lock. So, but we haven't had any clients come back and tell us, hey, you filed this and you gave us a number, but the sheriff's not doing it. So, due to the fact that by omission, I would say it hasn't been any issue.
Okay, great. Now, so you're saying that the CDC's ban on evictions is actually a recommendation that the states can adopt or not adopt?
Correct, which is why
Wow.
we're still been able to move forward with breaches of lease, tenants holding over, and wrongful detainers.
And then in the governor's order, the order states that the tenant, in order for if the landlord files a failure to pay rent notice, that the tenant has to demonstrate to the court through documentation or other verifiable means that the tenant suffered a substantial loss of income resulted from COVID-19 or related proclamation of a state of emergency or catastrophic health emergency. I'm wondering if you have any experience, or if you're hearing anything about our tenants putting forth this defense, and how effective are they, or what level of effectiveness are the tenants having in taking this claim, and what sort of documentation are they showing that's working and what's not working?
I can tell you, unfortunately, I don't have an answer in terms of a concrete example. I haven't had any clients tell me. That being said, knowing our court systems as I do, and knowing the Maryland court system on the whole, I will tell you that it's going to be a very low bar that they're going to have to show that they were affected by COVID, and that was the reason they couldn't pay. That being said, I think that landlords and property managers should be ready to argue, yes, you may have lost your job. However, that the tenant, you would then, your cross-examination questions would go into, did you file for unemployment? Were you receiving unemployment? Did you receive money through the CARES Act? How much money do you receive through the CARES Act? How much money are you receiving through unemployment? Because I know many people who are actually receiving more money per week due to the $600 that was tacked on top of the unemployment claim than they were when they were actually being paid. And so I think what landlords and property managers and owners need to be prepared for is to fight back on that. Don't just take the tenant saying, I lost my job so I couldn't pay, as a reason that they shouldn't process your failure to pay rent. I think you need to become armed with the facts of, this tenant was paying $1,000 a month, November 2019, December 2019, January 2019, February 2019, January 2020, February 2020, March 2020. Pandemic hits, yes, they may have lost their job, but this is the evidence to show they've said that they were actually receiving more money. They received money through the CARES Act of $3,400. That's over almost 3.5 months worth of rent that they could have paid, and they haven't paid anything. So while, yes, they may have been affected by COVID-19 and the pandemic, they weren't suffering a substantial loss of income just due to the fact that they were able to get money through the stipend, or the money that came from the federal government, as well as through unemployment. Mm-hmm. And I think that what everyone should do is make sure to harp on the governor's order that says specifically substantial loss of income. As Mr. Frederick said, he was reading it verbatim. That's what you need to harp on if you have these tenants that are trying to tell you they couldn't pay because of COVID.
Good.
I wanted to, because I had answered the previous question. The question here about if I have an unpleasant tenant, I do not wish to renew at the end of the lease term, do I have to provide a reason? Not necessarily. I mean, it can be a business decision for you to say, I am not renewing your lease. The reason I say to be wary of that is if there is a reason that the tenant could potentially come back and say to you that you are being retaliatory. But if they have not given you a reason that they would file a retaliatory action, you don't have to provide a reason. It's a business decision. You don't want them as a tenant anymore. You want to find somebody else. And the easiest way to say that is, as I was saying earlier, you know what the fair market value of the area is. Their rent has been 1,000 and you believe you could rent it for 1,200 and you didn't believe that this tenant was going to pay it. And as a result, that's why you gave them the non-renewal.
Yeah. I've often suggested I've done it myself and suggested to my clients and customers that unless it's a retaliatory situation, as you're suggesting, where you would really need to provide a solid business decision that's not related to the retaliatory matter, it's better to give no reason. Because any reason I gives them a reason to dispute it or refute it or counter argue it. And it's just like, if I just give them, I just want my property back. That's all. I just want my property back. I don't have to give a reason. So don't give a reason.
Yeah, I'm sorry. I apologize if I made that confusing. I wasn't telling you have to give the tenant the reason. I'm just saying you want to make sure that you have a reason somewhere, either in your file for that tenant or somewhere that you're keeping that.
If it
So
gets challenged in court, you want to have a reason. Yes.
Exactly.
Yeah. Okay. Great. Good. Okay. Terrific. Now, in the law for filing court notices, I seem to remember, maybe it's changed, but I seem to remember that in the law it says that when I file a failure to pay rent case in rent court, that the law says that the court has to give me a date like 7 days after the date that I file. And of course, we've been, for the past number of years, we've been getting court dates, 14 days out. And now with the pandemic and getting, the courts being closed, we're seeing court cases being set for, 3 months from the day I file. And I, can appreciate that the courts are backed up and you can't pack the court, with a lot of people. You have to be mindful of how many people are actually in the court. So all of that makes sense. But I'm just wondering and curious what your thoughts are, Jason, or if you've heard anything about, will this become the new normal? Because the tenant advocates, they always seem to want to do anything they can to stretch out the time, delay, defer court cases, delay, defer evictions, slow the process down as much, anything that they can grab onto. So I guess there's the fear that I have is that this, setting cases for 3 months out is going to become the new normal. Do you see anything like that happening, or do you see it going back to a normal 7 to 14 day date once we kind of get through this?
Yeah, you're not going to like my answer, but it's the former. I think that this is going to be the new normal, at least for the next year. Even in the even civil cases that we would file for collections, for example, we're seeing, because the court prefers to have, even though we were talking earlier about how they are setting it up so that we can have remote hearings, they would prefer to have in-person hearings. And so they're setting cases for next August in Baltimore City.
Next August?
Yeah, we had a client ask us if what we sent them was correct, and I said, yeah, it's August 12th of 2021 is a normal civil case that we are taking.
Wow.
So I think that, unfortunately, for the foreseeable future and potentially the unforeseeable future, this is going to be the new normal. It's just until the courts, until society as a whole, and I don't want to get into the machinations on that, but until society as a whole can rein this in, I think the courts are going to err on the side of caution and are going to function as they are now for the foreseeable future. And I really do think it's going to be through 2021. I mean, we saw that Baltimore County is not doing, if you have a jury trial that is longer than 3 days, which sounds like a long time, but if you have attorneys on both sides and 3 to 4 witnesses, which you see a lot of times in jury trials, a lot of them end up being 4 to 5 days. They're not setting those in until 2022. So
Jeez.
yeah, I mean, they're taking the long game on this, which for safety purposes, I think is smart, but it is frustrating. I very much feel for all of our clients and all of you on this call when you have tenants who are gaming the system because they know there's nothing that we can do at the moment.
Mhm.
But I think that the court's trying to take that extra step to make sure that they're keeping everyone as safe as possible.
Mhm. Is a similar thing happening in criminal court? Do you know?
That I can tell you truthfully, I'm not 100% sure on. I know that as when they did the 5-tier system, which was tier 1 was when they just shut down completely. Tier 2 started on, I believe it was June 8th. They started back with criminal and emergency peace and protective orders, which they were still doing those anyway. During the pandemic, they had certain judges that were available, obviously, for things that had to happen. You couldn't have nothing going on, but they were only taking emergency cases. In terms of criminal, unfortunately, we don't do much, so I couldn't speak to that.
Okay. During the pandemic, we're hearing things like, people are stuck at home, so drug use is increased, alcohol abuse is increased, domestic violence is increased. Are you seeing that impact landlord-tenant cases?
I will tell you that I have not seen this many breaches of lease, non-renewal tenant holding overs. I have not seen this concentration of them in years. So I would say, as a roundabout answer, yes. I think our clients are seeing it, coupled with the fact that the easiest way to always get tenants out before, even if they were a problem tenant, was they're not paying rent. You file the failure to pay rent. Yes, you can give them a breach of lease. Yes, you can non-renew them, but they're 3 months into a year lease, or it's kind of a touch and go whether or not they actually breached the lease or if it was material or not. They didn't pay the rent, I'm going to get them out. Coupled with the fact that you can't do that now, I do think that it's becoming an increasing problem, and the simplest fix for landlords at that point is to give the 30-day notice. Whether it's an increase in the number of problem tenants there are, or the more stringent, more strict action that our clients are taking because due to the fact that they can't get them out under any other way, I am hearing more complaints about tenants from clients. I wanted to answer this one quick question. If I have 3 people on the lease, one of whom is a parent or a co-signer, and then tenants have been paying during COVID on a payment plan but fall behind, do you recommend filing a failure to pay rent against all 3? I would say file it, yes. And you want to file against all tenants on the lease. It doesn't matter if it's an $1,800 lease, you have 3 tenants, and from them that they're each paying $600, and you've received $1,200 out of the $1,800. You're not filing against one tenant, you're filing against all of them, because even though you have tenants that may be splitting the money, to you, they owe you the $1,800. It doesn't matter how they're splitting it. And so you want to file against all of them. And I would file it ASAP, just due to the fact that you want to get into court sometime between now and the end of 2021.
And Jason, we've recommended our lease agreement. It has names all of the tenants that are on the lease that are legally responsible for the lease. So we name, Jane, Joe, and John, and then we write the words joint and several. And so if
Who'd you hear that from?
Jeff Tapper.
Sounded familiar.
Yeah. So the idea is that if Jane and Joe are paying the rent, but John is not, it's like, I don't care. I'm not going to evict just one of you. I'm going to evict all 3 of you. All 3 of you on the lease, all 3 of you are jointly responsible for the rent. So if I'm going to file or sue any of you, I'm going to sue all of you. If I'm going to file for failure to pay rent, everybody gets evicted. I'm not going to be evicting just one roommate.
Yeah, you don't want to get into the splitting of hairs that way and splitting who was paying and who wasn't, because then if you were to try and evict one, which I don't even know how that would actually work, but then you have an issue of, well, you've evicted one tenant, but you're now only getting $1,200 of the $1,800 that you were previously getting. You're expecting the other 2 to pay. Eventually, you're going to just get them out because they have to pay what was 50% more of what they were having to pay in rent originally. So
Yeah.
it doesn't matter. Mr. Frederick, Tom, and Cheryl can all owe me each $1,000. They owe me $3,000 between the three of them, and they decide to pay me $1,000 each. I don't care. It can all come from Mr. Frederick. It can come from $1,000 from each of them, $1,500 from two of them, and $0 from one. It doesn't matter. They all have to pay that total of $3,000, and that's what joint and several liability is. They all together owe that money, but each separately will be held responsible if the whole doesn't pay.
Yeah. And from I guess from a human nature, psychology, or motivational point of view, is peer pressure is the biggest motivator. In other words, if I call up the tenants and I yell at them and demand that they pay me the rent, I'm the bad guy. But if I say, look, if you don't get the rent from your roommate, I'm evicting all of you, then the two roommates, they're going to get on the case of the guy that's slow pay or not paying. And that peer pressure is a far bigger motivator than anything I could do or say.
Absolutely.
Good. Excellent. We were talking about some of the domestic violence, abuse, drug abuse, things like that. How are the courts handling those when you bring those cases and those actions for breach of lease, for domestic violence, or people have protective orders against their former spouse or boyfriend or whatever? How quickly are they getting processed, and how efficiently is the court system operating in that arena?
Similar to, I haven't seen anything slow down, put it that way, since pre-pandemic. In fact, one of the cases that I mentioned earlier was handled that very way. It was an abuse situation. I can talk about it because it is a matter of public record at this point. And our client gave the notice. An attorney got involved, and we were able to settle it, but they had set the case in. We had filed it earlier this month. It was set in for early. In fact, it was set in, I think, for about 10 days from now. So it's going to be jurisdiction specific, but they are setting them in similar time to what they were doing before. The good thing, I don't know how good is the best word, but the good thing that the court is doing is they are understanding the severity of breaches of lease, wrongful detainers, and tenants holding over. And because they are not affected by any moratorium that's been put on by the court, or excuse me, by the governor, they seem to be treating them as if they did when pre-pandemic, and setting them in as soon as they have spots available in the courts.
Okay. We've had a number of clients and customers have called me over the last few months, and they're frustrated. They're like, my tenant stopped paying me. And, at that time the courts were closed, or even if you file now, you get a trial date, 3-4 months out. And they're like, what do I do? Because the tenant is just simply not paying because they want to, or our perception is they want to play the game. Maybe they're playing the game, maybe they're not. I don't know, but that's the way it feels on our, from the landlord's perspective. And they're like, what do I do? And I have suggested to a number of my clients and customers that cash for keys is, an option that they ought to consider. If a tenant's paying $1,000 a month, and it's going to take you 4 or 5 or 6 months to go through the process of getting a trial date, filing the warrant of restitution, scheduling the eviction, actually, following through with a live eviction, you could be 6 or 7 months, from the day you file until the date you get your property back. So going to the tenant and offering them cash for keys and saying, look, I'll give you 2 months rent if you just leave. It's cheaper for me to pay $2,000 to get rid of them now than lose $6,000 or $7,000 in lost rent. Plus, if they're living in the place and they're not paying rent, are they damaging it and these kind of things. So it's much better for me to, pay the money up front, get rid of them, get somebody new in there who's going to pay and not, and not screw around with us. What are you seeing?
I haven't seen cash for keys as much for problem tenants. I see it all the time with wrongful detainers, squatters. People say, look, I don't want to have to file. I'm going to file. I'm going to get you out of the property. But if you want to get out of here sooner, I'll give you $1,000. That being said, I think your suggestion is fantastic. Extraordinary times call for extraordinary measures. Under normal circumstances, I would say I would never offer a problem tenant money to get out. But you're absolutely right. It's going to take, unless you have a breach of lease or you're at towards the end of the lease, you're not going to get them out for months and months and months. And then it becomes truly a cost benefit analysis of saying, look, I'll give you, and I wouldn't offer 2 months. What I would offer to tell them is, look, you haven't paid in 3 months. I'll give you a month, or I'll even give you $500 to get out, and I'll wipe off a month or two from what you owed prior. Try and limit the amount of money that you're actually putting out of hand. That's just in terms of the business model, I would say. But if they're not going to leave unless they have that actual cash in hand because they need it for the next place, that becomes a decision on your end.
Mm-hmm.
But I think that that's a brilliant idea, because you're going to have to cut your losses at some point. And unfortunately, due to the fact that these failures to pay rent are not being set in times that are going to be able to get them in, let alone the potential for an extension on this moratorium, because while it's until the end of the year, with everything going on nationally, there's a potential that the moratorium on evictions for failures to pay rent could be extended past, at minimum, past the winter, just because courts don't like doing it during winter anyway, let alone the fact that we're seeing an increase in COVID cases throughout the nation. There's no guarantee that 2021 is going to make any difference at the starting. So I think that's a brilliant idea. And it's thinking outside the box, which you have to be doing at this point.
Mm-hmm. Yeah. So I guess I threw out a number of $2,000, 2 months rent. I would start by offering like a half a month's rent, and then kind of negotiate or go up from there and see what their level of motivation is. But I also,
I'm sorry.
Yeah, I like your idea of, going and saying, look, you owe 3 months back rent. We're just going to waive that and forget it. I'm not going to sue you for that. Or actually, the way I would frame it is, I could sue you for that, and that would be a dig on your credit. But if you leave, I'm not going to do that. And like really emphasize the negative impact of not moving out.
Absolutely.
Mm-hmm.
Ben, and just in real life experience, as you know, everybody in the office knows, I've dealt with this twice in the past 6 months. One was a squatter, and there was some administrations there, but it came down to 1 month's rent, and they weren't even paying rent. That was what the partner rented for, and we got them out. And it was stopping the sale of a building. We were representing our client, and I went to them and handled it myself with my friend Tom here's help, and a police officer that came along with me. And that was in squatter's case. Got them out. Building was sold. We have another case right now where the gal just stopped paying rent, and there's some back and forth. And bottom line, I actually was negotiating with her this morning, and came down to $1,000. She was, I started at 500, went to 1,000. She said, "Fine, done." Second, I said 1,000. She said, "Done." So of course she has to sign something. They have to sign something acknowledging that, and then so it actually works. Is the bottom line.
Yeah.
And it's, for whatever reason, I think that fourth digit, once you hit, just being able to tell them you're giving them 1,000, that seems to be a good number.
Right.
Yep.
There was a question here that said, if a tenant doesn't pay for a long time and now the tenant owes me $3,400, but they only have $3,200, would it be a fair housing issue if he only pays me $3,200 at a discount price? I'm a little confused, and I'm sorry to ask you to see if you can follow up for me, but do you mean that they owe you $3,400 total and not monthly? Or I'm a little confused as to what you mean. Would it be a fair housing issue? I'm going to answer the question as I think you're asking it, but if I don't answer it, please follow up for me. If you're saying that, over time they've gotten to the point where they owe you $3,400 and they only have $3,200, if they're offering you $3,200, I would say take it, because you're getting, for all intents and purposes, I want to say 90 some odd percent. I'm not the best at math. Maybe 95, 93% of the money that they owe you. And similarly, again, I know Mr. Frederick will know this just from cases we've settled on his behalf. There have been many times we'll have cases where it's $5,000, and this is when the case has already been turned over to us. And we'll say, look, we'll settle for $4,000. And because if they're going to pay me $4,000 now or $5,000 over 5 years, you'd rather have the $4,000 now. So it's not a fair housing issue, but you can accept it. You don't ever have to file for a failure to pay rent if you don't want to, even if they don't pay you the full amount. I hope that answered the question. If it doesn't, please feel free to send me another question.
Jason, back to cash for keys. What do you recommend in terms of documenting that, and the actual exchange of cash for keys has to happen instantly, or where do you see landlords tripping up or making mistakes, making rookie errors in cash for keys?
By and large, the clients that I've seen have done a good job. So in terms of errors, I don't see too many. What I would say that you want to do is make sure when you show up that you have a contract, and I'm not talking a 10-page document. You can be a single page saying that I, Ben Frederick, as landlord / property manager of the property known as 123 Sesame Street, I'm hereby agreed to give Jane Doe $1,000 for possession of 123 Sesame Street. As I am agreeing to give $1,000 to Miss Doe, Miss Doe is agreeing to return the keys to me and physical possession of the property. It doesn't even have to be that legal. That's just me spitballing here. I have templates for certain things. I don't have one for this necessarily. You just want to make sure that you're acknowledging in there that you are giving them the sum total of what you're giving them, whatever the amount of money is. Make sure that the property is listed in there. Make sure that the parties are listed in there, you as well as the tenant's name, and that they are agreeing in return for that money that they are agreeing to give you the keys and return possession to you. Those are the big things. You want to make sure that any other discussions that have come about as a result of this negotiation are in there. For example, we were talking earlier where I said, I would tell them, look, you owe me 3 months rent, I'll wipe that. Make sure if that's the agreement that you come to, make sure that you've put that in the agreement. Everything that you have laid out as a condition for why you are getting the possession of the property back. Make sure that's in there. Yep. If it's as simple as you're turning over money to them and they're giving you the keys, it's easy. But if you're saying I'm wiping out 3 months rent, past due rent, and you owe me no rent while you vacate, you got to make sure that's in there.
And it's literally cash for keys. They don't get the money until I get the keys. And it's just like,
yes,
here, money, keys, right? It's
absolutely
instant. Yeah. I'm not giving you money a week ahead of time. Mm-mm. It's like right there, right then.
Yeah, no. Yeah, that would be, unfortunately, I've never had any clients tell me that they did that, but I can imagine it's happened. Do not give them money without the keys. You are handing them that cash, the check, the money order, whatever it may be that you're giving them. You are handing that to them as they're handing you the keys after they've signed that piece of paper that you drafted up for them.
Mm-hmm. Excellent. Good. Your specialty, Jason, is collecting past due amounts. So when a tenant's moved out, Cheryl and I will go through and we'll make a list of all the damages that they made to the apartment in excess of ordinary wear and tear. We'll also make a list of what rent, water bills, any other charges that they owe us. We'll deduct the security deposit. If they still owe more money than the security deposit, we turn the file over to you, Jason, and you file collection, and you'll garnish their wages, attach their bank accounts, go through all of that stuff. What can you tell the people attending our webinar tonight, our meeting tonight? Like, what are some of the key things that are important that you get in that file?
So the easiest way to answer that is everything. The issue that I have with clients, and then I'll actually answer your question, but I just wanted to say the way I always tell clients is everything, because I don't want you to have to pick and choose through what you have in a file to determine whether or not you think it's important. Let me make that decision. I will determine what's important. So the easiest thing is when you're putting your file together is just to take the entire tenant file and hand it over to me. But the things that I want to make sure that you have in there are You want to make sure that you have your application, because while we may have somebody named, my name's not all that common, and so we're probably going to be able to find a Jason Fratto in Maryland to track them down. But if it's a John Smith, I need a bit more information on John Smith other than John Smith at 123 Sesame Street. So I want that application, so I have their date of birth, I have their social security number. Obviously, the biggest and most important thing for us to have is the lease agreement. We need that lease agreement because we have to be able to show the courts that there was this legal document as to the reason that they owe you the money. In terms of communication, obviously it's nice to have communications between you and the tenant, whether that's emails, text messages. I know that was something that you and I had spoken about previously that you wanted to discuss. Anything that is written communication that you've sent to the tenant or they sent to you, I want that. But the biggest thing is then, as you said, that security deposit disposition. The tenant's moved out. You have done your itemization, given it to the tenant. When you send me that file, I need the disposition. If you keep a ledger, which I would hope you do, send that with it. Any invoices and or pictures that you have. So in terms of sending me the file, I want everything. But as you as a landlord, as an owner, the way you should keep that file is in that order. And you should be, when you are doing work in a property, if a tenant has damaged it, especially in Baltimore City, which is one of the more tenant friendly, but all jurisdictions in Maryland are very tenant friendly comparative to other states. You want to make sure that if you have paid any money or are charging the tenant any money for physical damages, that you have backup for that. So take pictures at the time of move out. If you have, try and remember to take pictures when they move in, so you can say, hey, this is what the property looked like. This is what it looks like now. And then any invoices. So Mr. Frederick, you hire Tom to do work for you in the property. Make sure you get an invoice from Tom telling you, yes, it was $400 worth of work that he did in the property. Keep every single backup, because but for very, very few judges, if you don't have that backup, they're not going to give you that money, despite the fact that you wrote it.
Mm-hmm. Okay. How important is it to have to make copies of the checks when the tenant's paying their rent? So to turn that over to you, so you have a bank account that you can maybe attach their bank account. Is that important or not really so much?
Yeah, actually, it is very, very helpful to us in that application to have where they work. And if they do give you a personal check, to make sure that you have a copy of it, even if it's just to show proof of the security deposit. Mm-hmm. And for your records, if it ever becomes an issue of them saying whether or not they paid rent, you're saying, hey, no, I have a copy of all your checks. But if you have those, yeah, turn it over to us, because then you can say, oh, they bank with M&T. I can file a bank garnishment with M&T. Or, hey, I see on their application that they were working for the state of Maryland, probably still employed there. Or they were working for this company that was a mom and pop shop. Well, we'll give them a call to see if they're still employed with them, even though it was a couple of years ago. Jeff has suggested to other people. I think it's going to look a little weird, but you can always try. If you have a long-time tenant, if you have a tenant that's been with you for 4 or 5 years, have them fill out another application or update their application to say if any of this information is no longer relevant or is no longer applicable, please let us know. And that's simply for you to be able to have the most updated information when they vacate.
Okay. When we take an application, I insist on getting a photo ID because number one, I want to know who I'm actually dealing with.
Yes.
Sometimes tenants come up and they say, hi, my name is Jane Doe, when it's really their name is Sarah Smith, so I want to know who I'm dealing with, but also I want to get a copy of that driver's license. And, when you're out on the properties, I don't have a copy machine. I just take out my cell phone and just click a picture of their driver's license. Done. I've got it. I also ask for a copy of their social security card. A lot of people carry them. Some people don't, but I want to get their social security card whenever I can, so that when somebody writes their number on a rental application, sometimes, a 5 looks like a 6, or, you don't really have the numbers right. So I say, I want a copy of your social security card just so I can verify that I have the correct number. How important is it to have those two cards, Jason, when you're trying to collect money from somebody?
It's huge. Obviously, having the actual Social Security card is the best, rather than having what they purport to be their Social Security number on the application. And you would be amazed and probably a little saddened to see how many cases that we've had in our office, at least over the 12 years that I've been there, that were a case of identity theft. And the problem is people were not taking those photo IDs. They were saying, somebody who was purporting to be Cheryl was showing up to 123 property management and saying, "Hi, I'm Cheryl. I have her information," and they're not asking for a photo ID. And so, Cheryl, you're getting dinged because unfortunately somebody, took your information, rented a property, and then you're getting served with papers from my office for an apartment complex you never lived in. So, getting a photo ID and getting a copy, and a color copy is best. I mean, if you're not able to, you're not able to, but it's much better both for us as well as us, because then we turn that over to our process servers. When we go to serve Cheryl or Tom or Will or Mr. Frederick, we want to show them, hey, this is who you're looking for. And if it's a picture that's literally just all black because it's been scanned 3 different times, it's not in color, it's not really going to help them. And so having color is huge. But get that information as much for us, trying to collect money for you. It helps you because you inure yourself in case you do come across one of those situations. As you said, you're looking at Jane Doe, but it's not Jane Doe, it's Sally Smith.
Related matter, we had, I'm selling a building down in Federal Hill. It's a small apartment building. And I was there showing it, taking some people through, and these 2 women showed up. And it was obviously a mother and a daughter. And the daughter was just in tears. She comes up to me. She goes, are you the owner? She goes, I gave $500 to this man to rent this apartment at this address. And like, he's not returning my phone calls anymore. I don't know where to find him and all this kind of stuff. And I'm just like, you gave $500 to somebody that doesn't own this property. I'm like, I just felt so bad for them. But I've had that happen twice in the last 2 or 3 months, where people have come up to me, with that sort of scam. So that is going around, where people will put an ad on Craigslist for a building they don't own. They talk to the people, they say, before I can show you the building, I need to get a deposit from you, and people pay the money and then they get turned off. Are you seeing anything like that, Jason?
Yeah, and actually, unfortunately, while it may be increased now, it's nothing new. I had a woman who, and it wasn't just $500, she was living there for literally 6 months, paying her landlord, and she was paying religiously. She was paying the amount of money that was due. She was paying on time, and all of a sudden, she gets this wrongful detainer from my office on behalf of my client. And when I got to court, she says, "I don't understand. I have this lease here from Joe Schmo. He's saying he was the owner, and unfortunately, he wasn't. My client was a property manager for the actual owner of the property, and the judge told her, she said, I want my day in court. And I said, okay, we'll let the judge, tell you. And fortunately, the judge was able to tell her without us having to actually go through the trial, to say, I feel you. It's horrible. I know you're not getting any answer from this guy that you were paying money to for 6 months. Similar to what you were saying, this person was trying to get a hold of him. But unfortunately, you don't have any rights to live there. And it's sad. It's sad that there are people that will do that and take advantage of people, but it happened pre-pandemic, and I'm sure it's going to happen a lot more as more and more people aren't able to keep these properties rented. I know we had a couple of questions in here. I didn't want to ignore a couple of these. One was, if water heater needs repair but property owner doesn't have funds to fix due to tenant non-payment due to COVID, does owner still have to pay to fix ASAP? Yeah, so long as the lease says that the landlord or the owner is responsible for fixing it, they unfortunately have to. Otherwise, they are breaching their lease. And then you have a situation where the tenant can vacate, saying that they were what's called constructively evicted due to your failure or your breach of that lease. they had to vacate. And then not only are they not going to owe you any rent, they could potentially sue you for the withholding of the security deposit, the failure to return security deposit, any damages that they received as a result of you not fixing it. So long as the lease requires it, unfortunately, yes, you're going to have to fix it. And then there was a two-part question here. Are the failure to pay rent cases not being heard in Baltimore City? We were talking about that a little bit earlier. It's not, people are not hearing them or seeing them being set until at least January of 2021, as even Mr. Frederick was telling me. You filed one in October that was being set in January.
Yes.
And then the second part of that question was, is the notice period for a breach of lease case in Baltimore City still 30-day notice from the landlord to tenant? It is. For a breach of lease, you can still give 30 days, even though the month-to-month non-renewal is 60, you can still give a 30-day notice, just because it's a separate thing. If they have breached their lease, if they have done something that is a material breach, then you can do so.
Yeah. Just back to your question about the water heater. It sucks, during times like this,
That's a legal term.
When the tenant's not paying and then something goes bad and you're like, man, I don't have the money, I'm not collecting rent. Why do I have to do this? And the thing you have to realize is that, we as landlords, we're in business. This is our business, is renting apartments and renting houses. This is our business. All businesses come with risk. And, it sucks when we go through these downturns in the economy, when we go through pandemics once every 100 years, but it happens. And you still have the legal obligation to provide the basic services, even if the tenant's not paying. It's not fair. It doesn't seem fair. It doesn't feel fair, but you just got to dig into your pocket and do what you're required to do to stay on the right side of the law. Because if you don't, as Jason was explaining, it just spirals. It spirals downward very quickly. The tenant can then file for rent escrow, and you get into rent escrow, it just drags it out. The tenant can file for, what did you call it, eviction?
Wrongful eviction?
Wrongful eviction, or
constructive eviction.
Constructive eviction, yes. And then they can sue you for triple damages if you don't send them their security deposit back. So it just spirals out of control. It's much better just to do what you're supposed to do, dig in. It sucks, it hurts, it's painful, but it's just all about, we do well in the real estate business, but being successful in the real estate business is all about surviving the downtimes. If you can survive the downtimes, you do really well. If you get spiraled down in the downtimes, you can be put out of business. So it sucks, but it's just the way it is.
We had a previous question that I had tried to follow up on, the 34 versus the 3,200. You can tell your tenant that they will not have to pay the rest. You can tell them that they are paying you a $3,200 lump sum, that you are taking that as a settlement. I will tell you that you wouldn't have to do it for all of your other tenants, but be aware that could come up and all of them are going to try and settle with you. But I still think you can explain that away similarly to say, look, this person paid me 90 some odd % of what they owed me at one time. It becomes more of an issue if you put tenants on a payment plan for that backup that's due and owing, and then you're not charging them the full amount. That's where you get yourself into an issue. Whereas in this situation, if you have a tenant who's saying they're going to pay you $3,200 rather than 34, and it's going to be paid in a lump sum, I think that's something that you should still do.
Well, fair housing is all about treating everybody the same, regardless of their protected class. It doesn't mean we treat all people the same, period. We treat them all
Correct.
regardless of their protected class. So if you make a deal with one tenant and there's a good business reason for doing that, but then if you refuse to make a similar deal with another tenant, and they are of a different religious belief or nationality or some other protected class, as long as you have a business reason for doing that, you're going to be okay. Although you have to defend that business reason.
Correct.
Yeah.
There are a couple other questions in here, Mr. Frederick, if you want me to answer them.
The other question I had, Jason, was about text messages. If I see a lot of my clients texting their tenants, I see a lot of tenants texting me, and So that's documentation of a conversation or potential agreements, or if I said something. When those things go into court, how do courts view text messages in terms of their binding legal nature or?
So, by and large, the courts understand that we have a changing technological world. Despite the fact that they necessarily haven't caught up with that, because they're still stuck in very old modes of filing things. The judges themselves understand that not everybody's sending a letter to somebody that's being signed for by certified mail. Courts really look for the fact of whether or not someone is getting notice. And if there is notice, then was there an agreement based off that notice? So anytime I've seen with text messages, courts have accepted them as a legitimate form of communication. And potentially, if you're making decisions of, yeah, I'll take, we'll agree to take $800 rather than $1,000 as your rent, they're going to see that as you had an agreement that was an addendum to your lease or an amendment to your lease, depending on what it is. So long as there's a clear discussion there and it's not your obviously initial legal document, you don't want to just be texting the lease agreement. But if you're having any changes or anything, courts typically and by and large that I've seen accept that as a binding form of communication.
Okay. Do you have any advice for landlords in terms of what they say, or just be careful what you write in a text message because it could come back to haunt you? Like where do you see people slipping up or messing up in that regard?
Don't ever threaten your tenants, whether it's threaten them legally, threaten them obviously physically, but don't be threatening to throw them out on the street. I've had many clients who said, if you don't pay your rent, I'm going to come over there and I'm going to evict you myself. Don't do that. Don't tell them that, you're going to get evicted. I'm going to make sure that I do everything I can to get you evicted. Well, there sets up your retaliatory eviction claim. When you're texting tenants, act like it is as if you were sending a letter to the tenant. Be professional. Address only what they're asking. Tell them what only they need to know. Text messages, so many times you can see that people say things either out of anger or out of frustration, and that's even in a business setting. You want to make sure to know that can and will be probably brought up against you in a case if you decide to go up against them. And there have been plenty of times I've seen text message conversations that while my client has said some good things, they've said some very bad things, and where that comes in and weighs itself becomes an issue. So limit the type of conversations you're having to as if you were sending an email to a coworker or to another business. This is, your tenant. It doesn't matter what the form of communication is. You still want to have a sense of decorum with them.
Yeah. I would encourage people to have an outlet. Like if a tenant's like irritating you or jabbing at you, like call a friend, talk to your spouse or partner, like vent your anger that way, or have some other way to vent your frustration before you go back and respond to the tenant, so you can respond in a more professional way. I also like to let people know that you don't have to respond to every little jab. If a response is not required necessarily, and that's where things escalate and people start making mistakes. So I like to think about, I call them my empathy vocabulary words. So they're things like, oh, I'm sorry. Wow, that's too bad. Or, that must be tough. If somebody's saying, they're complaining about another tenant or whatever they're complaining about that doesn't really have anything to do with me or I really can't control, just to be able to respond in those kind of ways. Oh, I'm sorry that, that's really terrible. Or, those kind of empathy words instead of responding directly to their jabs if it's something I can't do anything about and if there's no positive way for me to resolve the situation.
I think that's the best way to do it, because otherwise you get yourself in a back and forth that's never going to end well for you.
Yeah. And instead of threatening eviction, I say if I don't receive your payment by the 5th, I'm going to start the process.
And you're not threatening anything at that point. You are merely just stating fact.
Yes.
If I do not receive the payment, that I will start the process. It's not a threatening manner in which you've said it. You are not threatening consequences. There's no legal statements that you have made. So I think that's if it comes to that where they're even doing that, I think that's the best way to respond. Do you want me to hit these couple questions,
Sure.
Mr. Frederick,
Yes.
that
Go
people
for it.
have asked?
Yep.
All right. So the first one says, currently my tenant owes me $19,000 for 8 months of rent. I filed failure to pay rent, etc., and is currently in a tenant holding over status. I've given the tenant several notices with a chance to vacate prior to court proceedings. The tenant has since taken out a peace order on me for harassment. Just reading the facts that you've stated, I don't see why they would have a peace order case against you. That being said, I'm not 100% sure of what actions you've taken. Please, by no means, take that as me saying that you've done anything wrong. I just don't understand why they even think that they could bring a peace order on that. So I think your statements, just based off of what you've said here, is you would just show the court, look, all I've told them is they owe me money. This is what I've done to tell them that they owe me the money due to the fact that they haven't paid and that it came to the end of their lease. I gave them a tenant holding over notice, and as a result, they filed this. I don't see any way a court's going to hold you accountable for this peace order. I mean, if you want to talk separately about this, I can I'll give everyone my email address and our office telephone number. You can give me a call, but I just don't see any way that that's going to fly on their end. If a tenant is not paid since April and I file a tenant holding over complaint in October, do I have to give a 60-day notice? Yeah, don't file the tenant holding over action until you give a notice. You have to give the notice first. So you have to give a tenant a 60-day notice, assuming it's a month-to-month tenancy. If it's a month-to-month tenancy and you want to get this tenant out and you want to do that now, you would have to give them the notice before the end of October that they have to be out on or before December 31st, 2020. And then if they don't vacate by December 31st, 2020, then you would file a tenant holding over action January 2nd, 2021. You can't file the tenant holding over first. You have to give that notice. Next question is, a tenant gives a 30-day notice, 30-day move-out notice 9 months into their 12-month lease. I checked property records and saw that they bought a new house nearby. They gave a reason for move-out using a clause on the lease meant for someone who either lost their job or moved away for their job, which is not applicable in their case. I asked for proof on how this clause applies to them. They never responded. What recourse do I have? You would look at them as any tenant who has vacated and prior to the end of their lease term. Make sure you keep that record that you looked on land records showing that they had bought a new property, and as a result that they tried to move from your property under, for lack of better terms, they lied to you. They moved under false pretenses. So they would be responsible until the end of the lease term or until it's re-rented, whichever occurs first. You would treat them as if they were an evicted tenant or a tenant who abandoned the property. They don't have any rights based off the fact that there's nothing in your lease that allows them to move just for buying a new home.
With that, what's the owner's responsibility to mitigate damages?
Great question. You have to do that which you have normally done for all other properties. So showing a court that you have mitigated damages is a relatively low bar. You just have to show that you took care of any damages in the property in a reasonable time. Reasonable is going to be case by case. If the property had $7,000 worth of damage and it took you a month to fix, that's reasonable. If all you had to do was change out a mirror or change out a couple light bulbs and you still said it took a month, that's unreasonable, and a court's likely going to ding you for that. But so long as you show that you have systems in place where every time I rent a property, I put it out on Craigslist, or I forget what the Zillow. I was thinking there's a realtor's listing site that they also use for renting properties as well. I forget what the term is, but whatever websites that you're using or whatever processes that you use, even if it's just putting up a for rent sign in the property, you just want to make sure that you are using the same processes on each of your properties that you are renting, and to make sure that you keep note of that. So that if a judge says, well, why did it take you 7 months to rent the property? You can say, Your Honor, it took me 2 months to fix the property. Here's the reason. Once the property was up and ready to actually be habitable, I then put it out on Craigslist, Zillow, Redfin, had all these showings. Unfortunately, people didn't want it, or it was out of their price range, but I showed it to 6 different people. So long as you can show the courts the reason why it took. And most of the times, judges aren't going to argue against it if it takes a few months. It's only in cases where it takes 6, 7, 8 months to rent the property that they're even going to have that question.
So in the case that the question came in, if a tenant moves out 9 months after on a 12-month lease, they move out 3 months early, you can't just sit on your hands and wait and say, oh, I'm going to charge them, I'm going to sue them for these 3 months rent, and not do anything until the 12th month is over. You have to get the unit ready, get it back on the market. And once it's re-rented, then you can assess your damages and then turn it over to Jason, and he can collect the money for you.
Absolutely. And then the final question in the Q&A section here says, if the property in Baltimore City has a no pet clause in the lease and the tenant has pets without landlord's consent, is it a breach of lease? Yes, it is a breach of lease. However, what I will tell you is a breach of lease action in Maryland requires you to show that there's a breach of the lease, that there is a material breach, so that breach is actually material. It's not, oh, you chipped something on the windowsill. The breach is material, that they had a chance to cure, and that it is worthy of eviction. Those are your 4 prongs that the court's going to evaluate. Keeping pets in a place that has no pets, I would say most courts are going to say, yes, that is a breach. Yes, it's material. That's going to be the biggest thing for you to have to figure out. Did you give them the notice or chance to cure? Did they not cure? And is it evictionable? But it is a breach. It's just proving to the court that you've met all of those prongs. And sometimes it's not as easy as you would think, just based off the fact that, as I said earlier, where I had that one where the woman sent the person to their, not only themselves, but their neighbor to the hospital for smoke inhalation, because the court said that it was not worthy of an eviction because it was an accident. Even though it was a breach, it was a material breach. You gave them the notice, but it was just an accident. It was a one-time thing. And then the final question here is, if a tenant breaks something but then denies they broke it, what's my remedy? That becomes a he said, she said. Unfortunately, without concrete evidence against them, obviously it becomes a he said, she said. It does become, in the legal field, what's called res ipsa loquitur. For example, if I show up and I see Mr. Frederick's car rammed into a tree, I didn't see it happen, I'm going to assume that he ran his car into a tree. I'm not going to assume that the tree jumped into his car, because it's an inanimate object. So res ipsa loquitur is the legal term of it's saying, even if you didn't see it, that's the likelihood of what happened. So what you want to do is you want to determine, are the facts going to show that they clearly broke this? And if they are, then you would then continue to try and say, no, you're responsible for this. If the facts can't prove it, I don't know what you're going to do.
Is the tenant not responsible for everything that goes on inside their household? Like if one of their guests or one of their kids broke something, the tenant is responsible.
That is correct.
If something's broken inside the apartment, I didn't break it, so they must have, or someone under their control or purview must have broken it, and they're responsible. Yes.
Yes, and you are responsible for any family. A tenant is responsible for themselves, all other tenants, all other occupants, and or guests in the property.
Mm-hmm.
Mr. Owens is asking for my email address. My email address is Jason, Jason, at tapperfratto.com, and I'm going to put it in the chat for everyone.
That's TAPPERFRATTO.com. Jason@tapperfratto.com.
And it did auto capitalize Jason. You don't actually have to capitalize that J.
Got it. Okay. Cheryl, Tom, anything to add?
It was good to learn that the retaliation clause is 6 months because I think we thought it was less than that.
Yeah, and even then, I think you really run the risk, even if you're getting close to that 6 months. You really want to make sure that all your ducks are in a row, especially if a tenant did have a successful rent escrow against you. Make sure you know what you're doing when you're doing those.
And the only other thing, Ben, I would add is we did have a failure to pay. I filed it September 8th, and the tenants didn't even get the court notice until September 30th.
Wow.
So it's way past the 7 days.
Yeah.
And that, of course, that court date was for January 20th or something, but you're talking 22 days for them to be aware.
Well, they're getting it back together slowly but surely. Yep. Very good. All right, Tom?
No, Jason, I think that you provided a ton of information tonight. Really appreciate you joining us, and thank you for sharing your expertise.
Yes.
Not a problem. I very much appreciate it. If you need me at any other time, I'd be more than happy to do so. I will say, I'm sorry, this is my partial OCD nature. I see two final questions that I do want to answer for everyone, and then I promise I won't keep taking things because I know that we're at the end of the time. But I see one question here that says, if a tenant in Baltimore County gets evicted for non-payment of rent, are they still responsible for rent for the remainder of their lease if the property remains vacant for the duration? Yes, that's where Mr. Frederick was pointing out, though. You got to make sure to show court that you are mitigating your damages. If they move out 6 months into the end of into a year lease, if you are unable to rent that property within that final 6 months, they are responsible to you for that rent for those 6 months. But you have to show court that you didn't just sit on your hands. You were trying to rent the property and you weren't able to, or it was so damaged that you weren't able to even put it up for rent for a few months. And you cannot charge that tenant until the end of the lease. So in other words, if they move out at the 6 month, at 6 months into a 12-month lease, you can't send them your disposition saying you owe me until the end of the lease. Accelerating rent in a residential lease is prohibited. So you can only charge them as the months go on. So if the tenant, now that you can charge them October's because you haven't rented October, but you can't charge them November's rent until the end of November because you don't know if you're going to rent the property at any time during that month. And then yes, we do work in PG County. We do work actually all through Maryland, except for your Western Marylands and your far Eastern Marylands. You don't want to pay me for driving out to Ocean City. But yeah, we do work in Baltimore City, Baltimore County, Cecil County, Hartford, PG, Montgomery, Howard, your major ones around Baltimore City and extending. So if you ever have a question for any place, you all can just email me and I can tell you whether or not we are able to do any work there.
You want to share your phone number?
Oh, sure. It's thank you. Totally forgot that part. I'm going to put it in the chat, but it's 410-363-2355. Again, if I'm for whatever reason unavailable, you can also ask for my partner Jeff or our associate Andrew. They're also, they're not as awesome as I am, but they are willing to talk to other people as well.
They'll get by. Jason, thank you so much for joining us this evening. Really appreciate your time and your expertise, your knowledge and experience, very much so. It's really a great honor to bring quality people to our forum here and be able to share knowledge with our customers and clients. My name is Ben Frederick. I'm here with my associate Cheryl Sedera, my partner Tom Fair, and my partner Will Cannon. So my name again is Ben Frederick. We specialize in helping people buy and sell apartment buildings throughout the Baltimore metro area. We look forward to being of service to you. Our website is benfrederick.com, and we look forward to working with you soon. Have a good night, everybody. Thanks for joining us.
Thanks, everyone.